Hello everyone, I'm Ron Jankowski with Channel 4 and welcome back to Wills, Trusts and More. And of course I have Eileen Kerlin Walsh. Did I say that right?
You did.
Okay,
and
Eileen's law offices are 11301 South Harlem. And Eileen and I are going to talk again. We've had some phone calls for some viewers, and we're going to start out talking about condo law and what the board members should be doing or shouldn't be doing, and they have some questions. And I have some questions here about the board options when a unit owner stops paying assessments. What are the options when someone says, I had it with this board, I don't like what they stand for, they're not cooperative with me, I have my own way of doing things, and they refuse to pay the assessment. Now what happens?
Yes, not a good situation, Ron. And it can happen because a unit owner is no longer happy with the board and this is their stance, or it can happen, and what has happened more frequently in the last couple of years is that the economic downturn has hit the condominium association, has hit the unit owners, and they suddenly find themselves in a position to be unable to pay. Now that has been really difficult for boards to handle. And if a unit may or may not be going into foreclosure, but if someone is in trouble, one of the first things, or certainly one of the things the board has noticed that stops getting paid, are those assessments. And as we've talked about before, those assessments are the lifeblood of the association. Mm-hmm. They're essential to the budget and they're everyone's responsibility. So what a board needs to do is take action as soon as possible. That's the most important thing. Often boards, and we certainly talked about kindness and tolerance the last time, we talked about trying to be compassionate. And we would certainly intend for the board to reach out to the unit owner and see if there was some way to resolve this matter. But if the unit owner is either absent or completely recalcitrant and nothing can be done, the board needs to take action as soon as possible. First thing they need to do, step right in there and follow the procedures. Give adequate notice. Give an opportunity to be heard. So we always need to follow the procedures. But if there still is no response or resolution, the board does have some options. They can file an action against the unit owner, just as a landlord could against a tenant not paying. They actually have a statutory right to take possession of that unit. This is sometimes boards don't realize that power that they have, and it can often be a very unpleasant surprise for the unit owner. But if they take all the appropriate action, what the board can do, and this is usually where they would get an attorney who specializes in condo law on board, get the action filed, again, follow all the proper steps, and within a few months, they actually have authority to take possession of that unit for the purposes of recouping their losses due to the unpaid assessment. So the board can actually then rent out the unit and be able to make up for those losses. And obviously, the sooner they start this process, the quicker it will be for them to rehabilitate. So it's a wonderful option, Ron, and something boards really do need to know about, and the sooner they get on board with the resolution, the better.
Well, part of those steps probably includes eviction. If they refuse to move, they're in a foreclosure process. Well, then the board has to go through that step, get them evicted. Then they have the authority, is what you're saying, to actually rent that unit out.
They do. They do have the authority to rent that unit out, and this is a wonderful way to maintain some stability and to get to ultimately recoup the losses, because the loss of those assessments, especially if there are several units that are in this situation, can be just very, very damaging to the health of the association and the budget, and suddenly everyone's suffering. So while we want to be tolerant and compassionate, we cannot hurt the entire community. So action does need to be taken. The board needs to know what their options are, and getting possession of that unit is really a terrific way to begin some recovery.
Okay, let's say they have possession now. Are there rules on renting the units that maybe they should be aware of?
Well, there are some rules, and ultimately, the aim of the renting is to recoup the assessments. Now, if they are successful and taking over the unit, and they do get a tenant in there, and they get to the point where they're now in a position of equity, they would have a responsibility ultimately. Now, they can recoup their losses as to the assessments, any attorney's fees, costs, that type of thing can all be recouped. Ultimately, then that money would be set aside for the unit owner. But typically, sometimes boards are slow to even know they have this resolution or to take it, that it's not too often that we end up with a surplus. But there are some rules, and the board, if they get on board to begin this process, they're usually pretty good about getting themselves educated with that. And of course, the attorney who handles condo law who comes on board will guide them in the right direction when it comes to that.
Okay. Is that we pretty much covered?
There is another option.
Okay, we need to address that.
Yes, there is one more option when a unit is in distress. The unit owner, he is either disappeared or is still there not paying assessments, and the unit is in foreclosure. Now, the board is always going to be named as a defendant in addition to the unit owner because of the rights that they have. So ultimately, when the board gets this notice of foreclosure, again, if they have an attorney on retention, or this is a good point, this is a good position, a good time to get an attorney on board, they can actually file an answer, they can file their appearance, and they can piggyback the lawsuit. And at the end of it, they can get an order for 6 months of assessments to be paid by the new buyer of the unit, as well as all the attorney's fees, costs, and interest. So these options are there, and they're certainly worthwhile for the board to get on board to embrace, but they have to know about them. And I think this is a wonderful opportunity to let the boards know that they do have options. At least consult with an attorney when there is an opportunity to maybe do something to recoup the losses.
Okay, and I'm going to mention this on the air that if there are condo associations or members of the association that do have any question, because we're going to go on to other things, I just want to mention that you can call Eileen, and I'm going to give her number at the bottom of the screen, 448-5169. She's a local attorney firm at 11301 South Harlem. So if you have any further questions, I'm sure Eileen would be happy to address those questions.
Thank you, Ron. And before we leave the condo law for now, let's just talk about renting a little bit in general.
Okay, good.
It's a really hot potato and a controversial subject when it comes to associations, because there's this internal conflict where the board, the community ultimately wants stability. They want a stable community which is best served by resident unit owners. If we were talking about renting in general, that ultimately an association community likes resident unit owners. It's the most stable way to have a nice successful association. However, there are other times when renting is good for the unit owners. Maybe a unit owner's life situation has changed and they now want to move out into a single family. They'd rather rent their unit than sell it, and maybe there isn't even a market for it to be sold in. Or you could have someone who simply cannot handle the cost anymore. Let's look back at that time when there was all this, wonderful free credit and credit that people really couldn't afford. And now suddenly they have a unit that they cannot afford to pay for themselves, but maybe a tenant could. And then there are some property investors who want to invest in a condo because of the lower investment cost, and then of course there are renters who want the lower cost of a condominium unit rather than a single family. So all of this leads to some conflict and some controversy over whether the units can be rented or not. So I think the overarching rule is, if you are a buyer, check to see what the rules are. If you're going to get into that unit as a long-term investment and you don't want to be with what are considered more transient residents who are renters, check the association declaration, find out if it can be rented. And if there are renters in there and that's not what you want, don't purchase there. If you're a property buyer and you know you want to rent the units, find out before you purchase whether those units can be rented. That's a great way to avoid these problems straight off. If you're already in and you purchased it to rent and realize now that you can't, or you've started renting and you realize that you shouldn't have and you're in violation, then you either have to remove your tenant, or they will be evicted and you will be sued for breach of contract, or maybe everyone could work together to amend the declarations. And it really is down to the philosophy and the financial robustness of the association as to whether they might amend to allow some renters in difficult economic times, or whether they're rigidly going to stick to that secure resident unit owner that they want. So everyone ought to educate themselves about what that particular association allows, what the law is, what their needs are, and try to address that difficult problem of renting up front and before any problems occur.
Okay, that's a good comment in conclusion.
Yes, thank you.
Okay, now, our March show was on ethical wills, and viewers wanted to know whether an ethical will was a legal document. That's an interesting topic.
Yes, and I just spoke this morning on ethical wills to the Kiwanis Club in Aurora. So as you know, this is a subject very dear to my heart. The answer is no. An ethical will is not a legal document, because as you might remember, that ethical will is that lovely journey through your life whereby you write a letter for your family and you glean the meaning of your life, your values and your beliefs and what your life has meant, and you write it down with the intent to inform your children, your loved ones, what your life has meant and how you would want them to be informed by your life and maybe make their lives a little bit better. It can be written side by side with a legal document. And as you might recall, we talked about situations where clients want to put some personal information along with their legal documents so that families understand a distribution or something difficult or the significance of an heirloom item. But we really would much prefer that to go in a side-by-side document. And I teach my clients how to write an ethical will so that that information doesn't compromise the legality of their other estate planning documents. And sometimes we just write an ethical will just as a separate life document that would be beneficial to you and that you would enjoy and that your family might enjoy, away from the legal context whatsoever. So it's not a legal document, but I think a very significant one, and one that my clients always enjoy to have produced. So very, very worthwhile.
Well, it kind of gives the person that is deceased, you better understand what that person really was. They may not have told you their values, but they expressed it in this document.
Absolutely. It's a beautiful part of one's legacy, and there are many people who have told me that they would much rather have had their grandfather's story than maybe the small trust fund that he had left for them. Or the amount is not the significance, it's that passing time and different times and stories and where we came from and that history and the meaning, and it's just all as valuable to children as the assets that they're getting. And we so assume that our children know everything, and sometimes they really don't. And then of course the value of the ethical will is in what we learn about ourselves as we visit our past and our history, and we think about the meaning of our life, because it's so significant, and your life is the most important life because it's a life that you've lived. So I consider it a really valuable document, although not a legal one.
Okay. Our next question is in the field of estate planning, which we covered back in late last year in 2012 and early this year, which reminds us that there are essential 6 estate planning documents.
That's
and I know you dwelled on them. Can you repeat them?
Sure, absolutely. The essential 6. The first is a will. Ron, everyone ought to have that last will and testament, the document that says whom you want to have your valuables, your assets. Now we're speaking about who you'd want be your executor. There are some rules and instructions. We can eliminate some of the cost of probate with a will, but we don't eliminate the process altogether. So if we want to eliminate probate, and most responsible clients who are doing their estate planning in a timely fashion do want to avoid their children the cost and the time and the very public nature of probate. So if we want to avoid that, then we come to number 2, which is a trust. Now the world of trusts is a vast and interesting and sometimes complex one, but very simply stated, a trust is a way to retitle your assets or make a trust the beneficiary of your assets so that everything goes very privately to whomever you want it to go to after you pass away. We completely avoid probate. We keep everything private. There are many more options for distribution through a trust than just with a beneficiary designation or in a will or putting children on the title to the home. So it's a really safe, a very clever, very economical way to structure your estate planning. And while there are many, many different types of trusts, ultimately they all come down to this streamlining, very private, very efficient, often money-saving way for your assets to go to your children or whomever is the object of your bounty.
Right.
Okay, now the third thing and the fourth item are powers of attorney for finance and healthcare. I love these documents. They're very simple, statutory, inexpensive to get in place, but they're to take care of you during your lifetime. Clients come to me, Ron, and I've told you this before, and they're concerned about their family, their children, saving money, keeping it private. How can we make this as easy for them as possible? And I say, well, certainly going to do that, but first we're going to take care of you during your lifetime. So the power of attorney for finance is where we name those trusted loved ones to take care of our finances if we become incapacitated. And unfortunately, a period of incapacity during our lifetime is very, very common, prevalent, and becoming more so as we get much better with the health of the body than the health of the mind and memory. The power of attorney for property, it's called, is for everything financial. The power of attorney for healthcare is for all our healthcare decisions. So we can name the agents, we can talk to doctors, authorized surgery, pharmacists, anything healthcare, we can get it into that document. Now, the nice thing about these two documents is this is avoiding lifetime probate guardianship. So a lot of the trust is for avoiding probate after death of your estate. During your lifetime, if we don't name someone in these documents, if we're unable to take care of ourselves in the later years or during an illness, then your family would have to go to the guardianship courts to get the authority to even write a check from your checking account. So this is a way that we can avoid that lifetime probate and have the people who are going to take care of you instantly have the authority to do so. Wonderful, wonderful documents. That's 3 and 4. Number 5 is end of life decisions. This is not an easy thing to think about, but most of us have a general philosophy for whether or not at the end of our life we would want to be kept alive by machines, death delaying procedures, all that kind of thing. Difficult to think about, but if we do know that we do not want to go through that kind of lengthy, expensive, and ultimately we're going to pass away anyhow, we can get that into your documents. We can get it into the healthcare power, and we can get it into this 5th document called the living will. This is all in the area of what we call advanced directives. And you can make many of these decisions now when you're healthy and competent and nothing bad is going to happen for a very long time. But we get those documents in place and they give you tremendous peace of mind. And with the living will, you're really making a difficult decision now, long before it's relevant, and taking it out of the hands of your family who are really not going to want to make that decision. It's going to be a lot harder for them at that time.
Right, right.
That's number 5. The last of the essential 6 is a roadmap to everything we've talked about, 1 through 5. We want your family to know that you have those documents and know where they're located. We want them to know what your assets are, where they're located, a nice list of the various banks, if there's CDs, if there's bonds. Where are they? Are there insurance policies? Are there beneficiaries named? Do we have contact people? Do we have numbers? That is essential, and that will take away months of difficult headaches for a family who have to do this when they're already in grief because their loved one has passed away. So if we can get all of that in place, we're never going to make it easy for someone to come in and take care of our estate either during illness or after death, but we certainly can make the process a lot more smooth and efficient and take away some of the administration difficulty that goes along with the grief during that process. So those are my essential 6 that I always highly recommend every responsible adult have in their estate plan.
Those are very, very important. And I just hope the viewers do understand the importance of them and do something about it. But to do that, they should be talking to an attorney.
Absolutely.
Yeah.
Estate planning is really a stitch in time, saving 9. It's a matter of understanding what these documents are, how they can benefit you, what the value of them is. And when clients understand the value of these documents, and certainly that while there's always an investment in estate planning, it's so minimal compared to the cost of guardianship or the cost of probate or even the cost of payment of taxes, it can be avoided with estate planning. So there's tremendous value to it, and often, an estate planner, someone who does this all the time and has a good deal of specialty in it, is a great place to start. We estate planners often will give free consultations, and I teach seminars on this, as you know, Ron. I teach seminars all over the Chicagoland area, educating people about these documents and what they mean and understand. Now, if our viewers do want all of this slowed down, because of course there's a limited amount that we can cover during this time, I do teach seminars at my office.
And I was going to go on to that. You do have educational type seminars. You do motivational speaking, and some businesses that have business events of some kind would probably love to have you come out and talk to their staff. And you do that.
I do.
If you can just
expound
a little about that, the type of thing. Because the viewers that we're talking to right now are going to be the ones that maybe will be hiring you to do that.
Lovely.
So we would like for you to talk a little bit about that.
Thank you. Ron, yes, I am a professional speaker, so I will go to corporations or organizations and speak either on my pre-designated subjects or whatever it is that they have a need for at that time. I very typically speak all around Chicago to organizations, financial planners, seniors groups on estate planning. So I do that once or twice a month. I also have seminars at my office. Our next seminar coming up on estate planning is next week, Friday, July 28th at 10 a.m. at my office at 113th in Harlem. So we have coffee and tea and cake and biscuits, cookies, that is, and we just talk about these subjects, and then my clients and the participants have an opportunity to ask their individual questions, which they do not, obviously, when we're talking about this in the show. I also, as you said, do motivational speaking, so I speak on my trademark back pocket skills for living well, loving life, and getting what you want, and that I'll either speak to corporations or non-for-profits, and we just talk about the basic building blocks of a happy, peaceful, successful life, and I adore to speak on that subject also. And I speak on ethical wills, business formation. I have even spoken on how to be a speaker, how to become involved in the professional circuit. So if anyone is interested in any of these services, I would be delighted for you to call me at my office, and Carl will give you the number after we speak. Ron will make it available for you.
Okay, and you know what? You're a dynamic speaker, so I'm sure it's exciting.
Oh, thank you, Ron.
I'm sure it is. Well, we're going to be breaking for the summer. And we'll be back. When will we be back with
September.
The next show? In September. So for the viewers that are watching us today, we'll be gone for a little over a month or so. And we will have another circuit of topics again to refresh everyone. We may duplicate some of the things we've talked about because we're probably going to be getting some questions from you viewers, and we do encourage that. You can call Eileen on the number at the bottom of the screen again and tell her what you're interested. You want an answer right now, she can give it to you. If you will have a topic you want us to cover and it relates to the topics that we cover, we'd be happy to talk and digress a little bit further into them.
Thank you. Thank you.
Eileen, you have a good summer.
Thank
and
you.
And for the viewers, you have
Always
a good summer.
Pleasure.
And
Thank
we
you.
will see you soon.
Thank you.